Dear learner, carrying forward our discussion to the approaches to the embarrassment of extraterritorial application of competition law in developed countries and the developing countries, we refer to Germany, we refer to Korea, we refer to United Kingdom, we refer to South Africa, we refer to France and European Union, and the kind of a conglomerate which we have made to look at the issue of approaches to the embarrassment of extraterritorial application of competition law that very reasonably switches us to see that the diversity of approaches which are permeated in the competition law and policy of extraterritorial application of the competition law at different jurisdictions. And to buttress this point and to bring home the conclusion, there is no other way to look at the entire issue but to see that what are those countries, what are those provisions, and what are their jurisdictional tests and what are their jurisdictional purview and the panorama to see very critically that what is the nature and extent of extraterritorial application of competition law, to what extent they have embarrassed in reality the intent and spirit of extraterritorial application of competition law. In that reference, dear learner and viewer, will be referring to the country known as Argentina. Article 3 of the competition law of the Argentina prescribes a jurisdictional test, and that test needs our attention. It goes on to say, and I quote, that all natural or artificial, public or private, profit or non-profit person performing economic activities in whole or in part of the national territory and those performing economic activities outside the country to the extent of their activities or agreement affect the national market are subject to the provisions of this law. What is the gist of the Article 3 of the competition law of a country known as Argentina? That it has very profusely made a distinction between the natural or the artificial, public or private, profit or non-profit, performing economic activities in whole or in part of the national territory, and those who are engaged in performance of the economic activity outside Argentina, then to the extent of their act or activities or agreement affect the national market, then they are subject to the provision of this law, is a kind of a provision which we find at the Article 3 of Argentina in relation to the competition law. Then we'll be referring to the other country, Brazil, and the Brazilian law under Article 2 of the law number 12.529 of 30, passed in November 2011, says that this law applies without prejudice to the convention and treaties of which Brazil is a signatory to practices performed in full or in part on the national territory or that produce or may produce effect thereon. A perusal of Article 2 of the law number 12.529 of 30, passed in November 2011, the Brazilian law have given a kind of a precedence to its law when it says that without prejudice to the conventions and treaties of which Brazil is a party or signatory, it focuses on the practices performed at the national territory but produce or may produce effect thereon, is a kind of a direct mention or a direct recognition of the effect doctrine of the United States antitrust law. Then, dear learner and viewer, we will be referring to the China, which is the largest country of the world, and we see the anti-monopoly law of the People's Republic of China passed in 2007, and directly focusing on we will be directly focusing on Article 2 of the anti-monopoly law of the People's Republic of China 2007. And this law says, and I quote, that this law is applicable to monopolistic conduct in economic activities within the territory of the People's Republic of China, and it is applicable to monopolistic conduct outside the territory of the People's Republic of China, which serves to eliminate or restrict competition on domestic market of China. Dear learner, we find a great sense of improvement on the diversified approaches to the embarrassment of extraterritoriality in selected developing countries. And as we discussed with you, the provision of Article 3 of Argentina, and we also discussed the provision or Article 2 of the law of the Brazil competition law and its incorporation of effect doctrine of United States antitrust law, we see a remarkable change in the very perception of the Chinese anti-monopoly or the competition law, which primarily try to hit to monopolistic conduct in economic activities within the territory of China, and it also try to see that the monopolistic conduct outside the territory of China, if it targeted to eliminate or restrict competition in the domestic market, are to be condemned under the spirit and intent of Article 2 of anti-monopoly law of the Republic of China. Then we will be looking at the Egypt, because the purpose here is to bring more and more and to showcase more and more laws so that we can discern the trends and the tendencies and try to exactly locate that what are the approaches to extraterritorial application of competition law when it comes to the embarrassment and recognition of the principle. Then we will be referring to one of the Asian countries, in that another country happens to be the Egypt, and Article 5 of the law number 3 of the year 2005, which talks about promulgating the law on the protection of the competition and prohibition of monopolistic law of 2005. So, very categorically, we find that in Chinese laws and as well as the Egyptian law, the word monopolistic tendencies are retained. And at the same time, it has the wishes of looking at that how competition law progresses. And the provision reads that the law shall apply to all the acts which are committed abroad should these acts result into the prevention, the freedom of competition in Egypt, and which constitute crime under the law. So, what is interesting to see under Article 5 of the Egyptian law on the protection of competition and prohibition of monopolistic practices of 2005, that it tried to see that prevention, restriction, or harm on the freedom of competition in Egypt is a criminal offense, not only a civil offense, meaning thereby that the Egyptian law carries a more deterrent value and deterrent effect. Now we turn to the Indian Competition Act 2002 and the Section 32 of the Indian Competition Act, which was inserted in the ANSEC case of United States, and then we see that it has been inserted by way of an amendment in 2003. It says that the Competition Commission shall, notwithstanding that an agreement referred to Section 3, it tries to see that it has power to look at the likely to have an appreciable adverse effect on the competition in the relevant market in India. Thus, we see the mandate of Article 32 of the Indian competition law have been a kind of a synchronization of the single unit doctrine, implementation doctrine, and as well as the effect doctrine of the US antitrust law when it says that it has an appreciable adverse effect on competition in the relevant market in India, then it may deem fit in accordance with the provision of this act to initiate any kind of an action. Then we will be referring to the Russian Federation law and the Russian Federation law number 135 FZ of 2006 on protection of competition, especially Article 3, Subclause 2 of the Russian Federation on protection of competition envisages that provision of this federal law are applicable to the agreement reached between Russian and or foreign persons or organization outside Russian Federation as well as action performed by them if such agreement or action affect the state of competition in Russian Federation. So even in the Russian law, we think and we feel that the shadow of the doctrine of effect or the effect doctrine of the US antitrust law looms large when it says that the action performed by them if such agreement or action affect the state of competition in Russian Federation, then it is to be condemned under Article 3, Subclause 2 of the Protection of Competition Law of the Russian Federation. Then Article Section 3 of the Competition Act of 1998 of South Africa also prescribes that it applies to all economic activity within or having an effect within the Republic. So, in the very prefatory notes, Article Section 3 of the South African Competition Act of 1998, and you may rightly recall, my dear learner and viewer, that the South African country, South Africa happens to be those countries which have brought competition law in 1990s. And as when we were studying the trends of the competition law across all the jurisdiction of the world, and we divided that development into the decades of 1990, the decades of 2000, decades of 2010, what we realized that South Africa have been one of the forerunner countries which have recognized the importance of the Competition Act in 1998, and a perusal of Section 3 of the South African law in the very beginning and the prefatory note says that the Act applies to all economic activity within or having an effect within the Republic, and then it goes on to enumerate some of the proviso except collective bargaining within the meaning of Section 23 of the Constitution of South Africa and Labor Act 1995, collective agreement. Number 2, the collective agreement as defined under Section 213 of Labor Relation Act 1995, and it talks about that any kind of a concerted conduct. Here it is to be seen that how South African Constitution and South African labor laws and labor welfare and labor relation law recognizes the collective bargaining and the collective agreement and give and accord a highest degree of right of the labor than that of the capital, meaning thereby it appears from the reading of Section 3, and that is something very revealing and astonishing to note that the South Africa, while legislating on the competition law and the Competition Act have made a special care that the rights of the labor class and the labor relation and the industrial relation be that has been prescribed under the constitutional conspectus of section 23 of the South African Constitution or the Labor Relation Act, the all kind of the collective agreement and collective bargaining are beyond the purview of this competition act, and it altogether defined the competition act in the non-commercial and socio-economic objective and similar purposes. And then it goes on to say that not only the collective bargaining, not only the collective agreement of the labor class, but any kind of the collective and concerted conduct which is designed to achieve the socio-economic objective or similar purposes are beyond the scope and ambit of this competition law, section 3. So it is precisely concerned with the economic activity within or having effect within the republic. That comes under the domain of section 3 of the Competition Act, and the provision has also some other kind of a regulation which deserves our attention in relation to the jurisdictions. And here your attention is drawn to the fact that how it tries to see the other public regulations and the commercial regulation and how it tries to dissect and decipher the differences and objective of the socio-economic laws and welfare laws and the constitutional law and the commercial law, and that way the South African Competition Law 1998 seems to be very comprehensive in character. Then we will be referring to the other country that is known as Turkey or the Turkiya in the modern sense of the term, and Article 2 of the law known as Protection of Competition Act, law number 4054. It covers all kind of agreement, decisions and practices which prevent, distort and restrict competition between any undertaking operating in or affecting market for goods and services within the borders of Republic of Turkey. So then it also goes on to suggest that abuse of dominance by dominant undertaking in the market or any kind of a legal transaction and behavior having nature of merger and acquisition which may significantly decrease competition or any transaction concerning the measure, observation, regulation and supervision aimed at protection of competition, that then the entire concept of Article 22 seems to recognize the four pillars of the competition law, that is regulation of combination, that is anti-competitive behavior, and abuse of dominance or any kind of the activity practices which distort and restrict competition is something, a very blanket clause which has been referred to the Turkey's Protection of Competition Act under Article 2. And then we'll be referring to more countries and conclude our lecture today saying that the other comes the country known as Ukraine and the law of the Ukraine on the protection of economic competition which has been passed in 2000. Article 2 subclause 2 says that the present law shall be applied to such relation that ensue from or can have an impact on economic competition in the territory of Ukraine. This law is very brief and succinct, but having a far-reaching ramifications on the issue. On it has in a very precise, accurate, and brief words the Ukrainian law on the protection of economic competition dwells and applies to such relations that ensue from or can have an impact on economic competition in the territory of Ukraine. And the last country which I will be referring to bring home the conclusion to you, dear learner viewer, is the Vietnam's competition law, which has been passed just 5 years back in 2018. And Article 1 of that law says that it set forth that the anti-competitive practices economic concentration that causes or may cause anti-competitive effect on the market of Vietnam, unfair competition practices, competition legal proceedings, sanction against violation of competition law, and state managed of the competition law are being condemned under the Vietnamese law on the competition of 2018. Thus, dear learner and viewers, what we discussed today in the lecture, that we try to decipher not only that what is the embarrassment of the extraterritorial application of competition law in the developed and developing countries, but we try to see and discern the nature, the trend, the tendencies and approaches which are prevalent in Germany, United Kingdom, South Africa, France, European Union, and a long list of the countries, namely Argentina, Brazil, China, Egypt, India, as well as the Russian Federation, South Africa, and Turkey, Vietnam, Ukraine, and to see in a very holistic manner that what can be said finally as a way of conclusion, that the entire study of this country leads that there are diversified approaches to the embarrassment of the extraterritorial application of the competition law, but one thread remains very common among all the laws across all the jurisdictions is the fact that the basic tenets of the competition law are being directly addressed by all these laws and across all these jurisdictions. And with this, I conclude and I hope that the entire issue of approaches to embarrassment of extraterritorial application of competition law, dear learner and viewer, will go a long way in deepening your understanding about the transnational competition law. With this, I just thank you. Thank you very much and have a happy learning.